The children are extremely upset by his lack of attentiveness and participation in their lives.
My client had a stroke, and that was pretty much one of the causes for the divorce.
Court will note the appearance of Ms. Reed on behalf of plaintiff, Ms. Greenlee-Clore on behalf of the defendant. This matter is before the court on the plaintiff's motion to modify parenting time. Ms. Reed.
Thank you, Your Honor. The parties share two minor children. That would be Jalen, who is 14, and Mia, who is 7. We're continuing to have issues with the defendant failing to exercise his parenting time. He did not exercise his winter break parenting time last year, and he did not exercise summer break parenting time this year. My client did provide the defendant a calendar of Jalen's football practices and events.
Buckle up, guys. Today we are stepping into a courtroom where emotions and broken promises collide. A mother stands before the judge, pleading for the protection of her children's happiness and stability. The issue: a father who, according to her, has repeatedly failed to show up. Miss Reed argues that the children are hurt, neglected, and losing trust. As this case opens, every word spoken could shift the future of 2 young lives.
During the summer break, as the judgment requires the parties coordinate defendant's parenting time around that football schedule, he did not contact her after that calendar was provided. He did not exercise parenting time. The children are extremely upset by his lack of attentiveness and participation in their lives. We're continuing to have issues with the defendant's consistent phone calls with the children, and when he does call, he talks to them for maybe 2 to 3 minutes, then demands to talk to my client, where he's verbally and emotionally abusive. He's abusive in emails and text messages. So what we're requesting is, because the relationship between the defendant and the children is so poor, and we've already tried reunification counseling last year when the judgment was entered, that his parenting time be exercised in Michigan, so not to disrupt the children's schedules and they feel comfortable.
This is where the mother delivers the core of her argument. She tells the court the father skipped winter parenting time, then ignored summer responsibilities as well. Even after receiving a full schedule, he made no attempt to stay involved. Phone calls barely last minutes, and too often turn into emotional abuse against her. She insists the kids feel safer at home in Michigan, and asks the judge to modify custody so the father must travel there if he truly wants to see them.
In Michigan, they can come home at night to mom, and that the children call him directly for these phone calls to stop the verbal and emotional abuse to me. So we're requesting a modification of parenting time, that spring break, half the winter break, and that 2 weeks out of the summer. Then it would come to Michigan and exercise that parenting time. It's my understanding that with Jalen and football, 2 weeks out of the year, 2 weeks out of the summer, rather, he has what are called dead weeks, and during those dead weeks, there are no football events, so he will be available for that parenting time.
Okay, thank you. Ms. Greenlee-Clore, I have reviewed your answer. You can add anything else you'd like to.
Thank you, Your Honor. I just want to reiterate that when we entered this judgment of divorce was entered merely not even a year ago, I believe, or close to it. At that time, it was clear that Mr. Wharton was not available to have his winter parenting time, as he already had plans for that year. That didn't go into the judgment, but that was already well known by the parties. As to the summer parenting time, well, let me backtrack a little bit. Mr. Wharton did have his parenting time in March for spring break. It went very well. The children had a wonderful time. They spent time with Mr. Wharton. They spent time with their grandparents. It went very well. When it came time to exercise summer parenting time, the summer parenting time calendar that Ms. Wharton provided, frankly, has no time for Mr. Wharton to have parenting time during the summer. She booked the younger minor child for 6 weeks, 6 out of 10 weeks for camp.
Here where the story flips. The father's attorney stands and says this struggle has been misunderstood. He claims the mother overloaded their kids, summers with camps and football, so the father had no openings left. He argues his client shouldn't be punished for children having pre-planned activities. He insists it wasn't neglect, it was the mother making it impossible. According to him, they need mediation, not punishment, and the court must protect the father's right to remain present.
I'm seeing gymnastic camp, cheerleader camp, all sorts of camps. And then the older minor child appears to have, according to this calendar, football events every single week except for a couple of weeks. At that point, it pretty much prevents Mr. Wharton from having his parenting time completely due to Ms. Wharton's actions. That put my client into an impossible situation where he could either say, hey, Mia, you can't go to all these camps. You can't go to cheerleader camp. You can't go to gymnastics camp because you have to come out here and spend time with me. Or telling the older minor child, well, hey, yeah, you've got these things scheduled, but now you can't do these. You have to come spend time with me. It's not fair to my client that Miss Wharton did this to him. He made the very difficult decision that, hey, these things are already set up. The minor children were already excited about them. That, okay, I guess they've got to go to these. These parties' communication is terrible. These parties also never participated in any sort of mediation. I think today what we need to get done is, I don't think the appropriate thing is removing my client's parenting time due to Ms. Wharton's actions. I think the appropriate thing would be to go to mediation, have these parties participate in mediation, and work out a way that, first of all, they're going to communicate regarding these children appropriately. And secondly, communicate with how they're going to schedule this parenting time and how Ms. Wharton can maybe work father's parenting time into these children's schedules during the summer. It's more important for these children to have a relationship with their father than to attend cheerleading camp or to attend a football workout.
Now the defense raises another critical point. The father suffered a stroke, one of the causes of the divorce. He can't travel alone and would require medical support if forced into Michigan visits. He already prepaid a vacation for next summer trying to fix things. His lawyer says limiting his time or forcing hardship would hurt the children more. It's not that he doesn't love his kids, it's that circumstances still challenge his ability to be there physically.
At this point, Miss Wharton's actions are what has kept these children away. My client has already taken the preliminary measure of booking a vacation for next summer with the minor children. He's already prepaid it. He's already scheduled it because he feels so terrible about not having the time with these kids over this past summer. But at this point, we have to move forward. We've got to figure out how these parents are going to co-parent going forward. These children, especially the younger one, they're very young. They're going to have a lot of more years left to co-parent. And I think sending these parties to mediation to figure this out would be the most appropriate avenue at this point. I don't think limiting my client's parenting time is appropriate. I don't think making my client come to Michigan is appropriate. There are no family members in Michigan. They're all out where Mr. Wharton lives. Additionally, my client had a stroke, and that was pretty much one of the causes for the divorce. My client would need to bring assistants with him to Michigan to exercise that parenting time. And that's also going to create a hardship to exercise that parenting time here in Michigan. So I don't think that that's appropriate at this time either. Again, I'd request that these parties be sent to mediation. Thank you.
Thank you. Ms. Reed, what are your thoughts on mediation?
My client does not wish to participate in mediation. We've discussed mediation prior to this hearing. We discussed mediation before the judgment of divorce was entered, and we don't believe the parties will come to any sort of agreement to resolve these issues.
The mother believes mediation is pointless. She says they tried counseling before and he barely showed. She argues he has no relationship with the kids because he doesn't maintain contact. 1-hour visits in 2021, reunification therapy that failed, missed calls that feel more like obligations than parenting. She insists consistency must come first. The children's happiness, sports, and life shouldn't be paused while the father decides when he cares enough to show up.
We've tried reunification counseling, and for the court's information, when the judgment of divorce was entered, we were not made aware that Mr. Wharton was not going to be participating in his winter break parenting time at that time. The judgment of divorce specifically says that the parties are going to work together to accommodate Jalen's practice in football during the summer. And the reason that that's in there is because that is one of the most important things to Jalen. And it is correct that, Mr. Wharton needs to have a relationship with his children, but right now, he doesn't have a relationship with his children because he's not an active parent. He's not actively participating. And we did reunification counseling last year because in 2021, he had seen the kids maybe an hour. And then last year it was reunification counseling, which was very, very rocky. And then now we're missing parenting time. We're missing phone calls. And it's important to have normalcy for these kids and not to take away their fun activities. And that's why we're asking for that week's.
Now the judge weighs both sides and takes control. He rules the father will keep his parenting time, no changes today, but the communication must change. The kids can now call father directly, keeping the mother out of the conflict, and neither parent can schedule activities during the other parent's time, preventing future excuses. The judge demands cooperation and warns both sides that putting children in the middle is unacceptable.
that they don't have those activities in the summer, that Mr. Wharton come out to Michigan to participate in parenting time. And once he's actually consistent in his parenting time and can show that he can actively do that, actively call the children, have conversations with the children that are longer than 2 minutes, and not verbally abuse my client, then we can talk about maybe having the kids go to Virginia again.
Okay. Well, what the court's going to do is order, at least that there was the issue addressed as it relates to phone calls. The court will allow the defendant to contact the children directly, or that they can contact him. As a result, the plaintiff will be out of the mix on those particular phone calls. In the answer, and as stated, there's a lot of reasons that parenting time was missed. So the court doesn't believe that there's a sufficient amount of time that was missed such that the defendant has to relinquish his parenting time. The court is not going to modify parenting time at this particular time. And the court will order in this matter. Apparently, with the one child, there was issues addressed as it relates to football, and the court would continue, obviously, that the parties would attempt to facilitate and work that out, but the court is going to.
As the case wraps, the judge orders both parents to share accurate football and summer activity dates. He encourages teamwork so the father gets real opportunities to bond. The message is clear. These kids deserve both parents without games, without conflict. The decision is final for today, but if either parent fails to cooperate again, this courtroom will be waiting. Thanks for watching. Don't forget to hit like, subscribe to the channel, and we'll see you in the next video.